Yeah, thank you very much. Good afternoon, everyone, and thank you for joining us for our session. My name is Holger Lutz. I'm a partner at Clifford, heading the Tech Digital Department in Germany. And it's my pleasure to introduce Michael Siegal, Director of European Engagement and AI Compliance at Amazon, who brings a deep experience in navigating the evolving digital regulatory landscape in Europe with the European Commission, the European Data Protection Board, member state data protection authorities, and other privacy thought leaders. Michael has played a pivotal role within Amazon on the engagement on the GDPR, the DSA, the DMA, and now the AI Act. His perspective is particularly valuable at a time when the EU is considering how to best balance robust consumer protection, regulatory simplification, and economic growth, as highlighted in the recent Draghi Report. The regulatory requirement for digital businesses is increasingly complex. We've just heard about that. We have overlapping requirements between privacy, consumer protection, and competition law. And we have seen the recent developments on the European state, which basically ended up in the withdrawal of the E-Privacy regulation. We have seen the discussions about the GDPR simplification proposal and the proposed data union strategy. At the same time, right, this is going into the right direction, but at the same time, we have seen that the European Commission has launched a consultation into a newly proposed Digital Fairness Act, which aims at addressing many topics that again overlap with privacy, right, and addressing points like personalization and marketing, which we thought would have basically gone in the discussions of the e-privacy regulation. In this session, we will basically explore some of the tensions between innovation and regulation and simplification. Having said that, Michael, how do you think that industry, as an industry leader, how industry can best share this perspective on the foundational questions of growth and regulation? And what does good collaboration between industry and regulators look like in practice, and how can it be improved?
No, thanks a lot, Holger, for the warm introduction and for setting the scene. I think when we're discussing digital legislation, it's imperative that there's ongoing exchange and discourse with companies of all sizes, with the regulators, with the legislators, and that's to make sure that expectations are well understood, that they match consumer preferences, and also that they're technically feasible. And in light of the Draghi Report, I think there is increasing understanding in Europe that we need to make sure that the frameworks are clear, that we understand how the different obligations relate and interact, and that most importantly, we understand the impact on SMEs who are at the heart of the European economy. So at Amazon, we routinely engage with data protection authorities and other privacy regulators and thought leaders. And that includes not only our one-stop shop for consumer data in Luxembourg, but data protection authorities throughout the member states, including Germany, at European level, with the European Commission and others. And we start that engagement and discussion with the fact that for us, it returns to our leadership principle around customer obsession and our relationship with the customer. And we understand that our customer data is just that. It's our customers' data, it's personal to them, and we respect that. And we know that our customers care about security. It's why we invest heavily with a staff team in safe and secure experiences. It's also why we create experiences that respect privacy by design and provide the experiences that EU customers want and expect. But on this kind of theme of exchange and discourse, I do think in the past year, there are some really positive examples to build on and to celebrate. And I would call out in particular the EDPB opinion on AI from last year. And I think the Irish DPC very wisely referred that question to the EDPB so that we could have a consistent European framework and view. The EDPB then held a stakeholder event, which I would really commend them for, that included industry of all sizes, consumer groups, privacy thought leaders, law firms, and they came out with a very sort of risk-balanced framework that allows AI development to move forward on a responsible path. if you look at just last year at this time, there was a lot of question about the role of legitimate interest as a basis for processing AI, which is key for innovation. And I think we now understand there is a roadmap forward. There are certainly details to fill in. I know that the BFDI has a consultation underway here in Germany, in particular looking into anonymization and what good looks like there, how we apply data subject rights. So this is an ongoing conversation, but I think we're very much headed in the right direction.
Yeah, and they did that basically before they issued the initial guidance papers, right? That was the very good thing on it.
Which is absolutely key, that you're seeking the input before the regulator puts the stake in the ground. Agreed.
Exactly.
Yes.
So the European market is pretty diverse, right? You have a wide range of business models and consumer preferences, as you just mentioned.
Yep.
What do you think? How can regulation better reflect this diversity? And what is the risk of a one-size-fits-all approach in that regard?
Yeah, it's a great question. And I think within the privacy bubble, we all know that privacy is a fundamental right, and we focus on that. But I think too often we forget that there are other fundamental rights and also competing preferences around what consumers want in terms of convenience and selection and experience. So maybe to start with one somewhat trite example, we can look at the cookie banner. And I think we can count on one hand the number of Europeans who find that a positive, privacy-enhancing, and meaningful experience. But then maybe turn into my own employer, Amazon, as a store. I strongly believe that most Europeans want a personalized shopping experience. To give a fact about myself, which is not particularly sensitive, I'm a dog owner. And when I go on Amazon, I appreciate that I see dog toys and dog food. If I begin to see fish food and cat products, that's not at all helpful to me. But we also need to consider this conversation around personalization, again, from the role of the SMEs. And the reality is that very few SMEs can afford to just sort of blanket advertise throughout Europe in the hopes of hitting their client base. You know, when we go out after this talk, get some lunch, it will be important that restaurant keepers in this area of Berlin are able to reach us. It will be of no help if we begin to see advertisements for restaurants back in Frankfurt or Luxembourg. Yep. And we all have heard about, certain privacy-enhancing techniques with respect to advertising. Contextual advertising is very trendy, and there has some real sort of innovation and possibility. I would take an example of a Scandinavian language bookseller. And the reality is that if you are looking at Danish language books, you probably speak Danish. Other Danish booksellers can probably show you their contents, and that would be interesting. But there are lots of other experiences, more generic experiences like what we just discussed, where that just doesn't work. And we need to consider the economic impacts there. But the last point, I'd just like to kind of pivot on this because the SME discussion is vitally important. But we also need to consider the interconnectedness of European data flows and the degree to which larger companies like Amazon support SMEs in the European economy, and it's mutually reinforcing. And I think if I look at some of the changes enacted so far around the omnibus proposals, I would strongly support them. But we need to be wary going forward of a system that begins to diverge or divide obligations based on size, particularly how that may impact the overall accountability principle in light of these connected data flows.
Yeah, okay, interesting. So another point which I mentioned at the beginning already is that the current digital regulatory landscape in Europe is often described as congested and fragmented. And you do have overlapping obligations from the GDPR, from E-Privacy, DSA, DMA, and now the AI Act. What is your view? Where do you see the most important overlaps and the areas of tension between these acts and the uncertainties, the resulting uncertainties for businesses, not only for larger ones, but also, again, for the SMEs? And what are the practical consequences?
Yeah, another essential question that we tackle. I think it needs to start by we need to be frank and honest where there are sort of tensions and trade-offs between privacy interests and other interests, be that competition interests, be that consumer interests. I think for too long in the Brussels bubble, we hear kind of X is without prejudice to Y, and somehow that all works, and there is no conflict But the reality, and we'll get into this, is we know there are tensions. And where there are tensions, business needs kind of clear guidance to understand, how do we divide these lines? Where do the responsibilities fall? How do we legally implement the obligations? And one example I would like to give here is around Digital Markets Act portability requirements. So as some may know, there are enhanced obligations for designated services under the Digital Markets Act with the aim of fostering competitive data ecosystems, which is a laudable objective in its own right. But as that obligation has come into effect, we have seen at Amazon some frankly scary applications from a privacy perspective. These may be applicants who are based outside of Europe in countries without a safe harbor or data transfer framework. These will be companies without the basic framework of a privacy program, lacking DPOs, not having clear privacy notices. They may have consents from customers consenting purportedly to the data transfer, but it's often very unclear how those were obtained. We all know about pay for consent or dark patterns. And to be very clear, we at Amazon have not greenlit any of these applications. No one needs to be worried. But the conversation is very much ongoing about what is the proper sort of safety and security vetting principles in line with GDPR accountability obligations versus the DMA portability obligations. Another example I would like to point out, which worries me a lot, is in the Digital Services Act. And here we have a provision around vetted researcher requests. And for those who don't know, this essentially means that if you have a PhD, you can request personal data from a company about its users and obtain that personal data without the user's consent. And from my perspective, while there may be other rationales that went into this consideration, this is sort of antithetical to the historical reasons for having privacy as a fundamental right in Europe and saying just because you have a PhD, you can access my data. That's something that really concerns me. So I do think, looking on the more bright or positive side, I do take heart by the fact that when I look at DMA portability obligations, the European Commission has now committed with the EDPB to publish guidance that will kind of sit across both files that will explain how do we sort of resolve these tensions. It's vitally important that the guidance is not in silos, but as in this case, it seeks to bring the regulatory community together. But we also need to look at the reality that we're 2 years after the implementation date of the DMA, and we still don't have the guidance or clarity for businesses. And this, to me, just really highlights the fact that we need to double down and focus on the simplification efforts. And I very much applaud what the Commission is doing in the omnibus regulations. There is early talk of e-privacy reform and potentially addressing the cookie banner, which is a source of frustration. I think there's work to do between GDPR and the AI Act. We have DPIAs, we have fundamental right impact assessments. How do they relate? Do they overlap? Let's kind of work through that. But in closing, and maybe as a word of warning, we've also seen, as you alluded to, this recent kind of consultation from the Commission about the Digital Fairness Act, which would be yet another horizontal piece of legislation. And I would really urge that we have a pause here, that we focus on the simplification initiative in line with the Draghi Report, really nail that exercise, and only then see what's left. Is there a real gap? What is the incremental cost of a new regulation versus just kind of throwing one more piece into the blender as we're trying to do this at full speed?
Yeah, and don't override the simplification efforts in other elements of the digital file, basically.
Yes, because what we may well find is that we fix some things through the omnibus regulations, but then mistakenly we end up readjusting them through the DFA process in parallel, which will just create enhanced confusion for business.
Yeah. Okay, thank you very much.
Yeah, thank you so much for your time, Holger.
Thank you,
everyone.